and India historically have had very high numbers of immigration to the U.S. That's why they have their own specific categories. It's a case where it's not good to be that special because it means longer waiting time. It's January 22nd, 2005. So that's the bad news. The other news is that, well, in November we thought that if the Republicans take over that we would not see immigration reform. But even though right now the projections are looking at possibly 15 years to get a green card for some of these situations, I don't think anybody will have to wait 15 years. Maybe I'm too much of a hopeful optimistic, but I think that immigration reform will come along so that you don't have to wait that long. But right now, that's what it looks like. So you want to be thinking about green card processing as early as possible. If you don't like that, there is another way, which is called EB-1. Does anybody recognize any of these people? I put this one up here because I figured, does anybody recognize this person? Say it again. Very good. I'm impressed. I didn't think anybody would get that. And then, of course, Einstein's the other one. If you win a Nobel Prize, that's what it looks like. You can go to Stockholm, and then when you come back, you can apply for what's called EB-1. So generally, most people will fall in the previous category, where you have to have the employer sponsor you, and then you take a number and you wait. Another option is what's called EB-1, and these are priority workers. And the regulations talk about different categories. There are a couple categories that are, there's one called extraordinary ability. You have to have national or international acclaim, so you have to be fairly well known. You don't have to have a job offer. That's in most employment-sponsored immigration, you have to have an employer. In this category, again, if you win a Nobel Prize, we're going to not require you to have a job offer because you're probably going to find a job. And then what you have to satisfy, you have to have a one-time major award, such as a Nobel, and a Nobel Prize is specifically in the regulation, or you have to meet 3 out of 10 criteria. And then I just put some examples here. You have to have a lot of publications, you have to have novel findings, maybe you serve as the judge of others, you're on a review panel, you've edited a textbook or something like that. But if you meet those criteria, then you don't have to wait in line for as long. You still have to go through the process, but you could get a green card much quicker. So that's extraordinary ability. Another category is called outstanding professor or researcher. It's similar. You still have to have international recognition. You do have to have a job offer. So you have to have a full-time job in that category. And then you have to have 2 out of 6 criteria. So rather than 3 out of 10, the standard's a little bit lower, but you have to have a job offer. And then, as you can imagine, and kind of the running joke in our office, another running joke we have is, people come in and they say, "Oh, I don't want to wait that 15 years, that's too long, I want to apply for EB-1, and we ask, have you won a Nobel? And we had somebody say yes. One time the person said, as a matter of fact, I did. The case was approved. But you don't have to win a Nobel Prize. I put that up there kind of for humor, but also to be serious, that's the easiest way, but there are lesser awards. I've seen lots of lesser awards. The Nobel is that's the most well known. Everybody recognizes what a Nobel is, but you can have a lesser award. It can't be for your Thursday night group of 5 people and you got the award for perfect attendance. That's not going to cut it. But again, a lot of people who come to me and ask about this, I turn away more of these cases than I take. And it's not because individuals are not doing important and meaningful things, it's just that the standard is so high that basically you have to be at the top of your field and you have to be very accomplished, you have to have lots of publications, you have to be recognized, you have to be reviewing the work of others, and you have to be making novel findings. And if you're just graduating, if you just got your master's or your PhD last week, then you may not meet that standard. But maybe in a couple of years, you can meet that standard. one other thing I left out. For the outstanding professor, you have to have 3 years of teaching experience. And that could be, if you're working on a PhD, that could, the time that you're teaching during the PhD could count. To kind of move gears here, switch gears here again, to talk about some practical matters, to look back again at the H-1B petition, and then also with green card processing, you want to inform the employer that there is a sponsorship requirement. That most employers, in my experience, they usually want to know pretty early in the process. And again, when I give this talk to students, I always kind of give a little bit of caution. You don't need to have it on the top of your resume that I need you to file an H-1B visa for me. But at the same time, you don't want to wait until the employer offers you the job and then say, oh, by the way, I need you to sponsor this H-1. I've seen offers revoked in that situation where the employer says, well, we're thinking about hiring this individual, and then this individual at the last minute said that there's this H-1B requirement. What's this H-1B? And I've never heard of this. And then, all right, let's calm down. Take it easy. And when sometimes employers, they don't like surprises. So I usually recommend, and that's something that you have to feel out with the chemistry. It's kind of, you go through the interview process, it's very formal. And when the time is right, hopefully you'll know, but don't wait till the last minute. And for a lot of organizations, if it's a large organization, they probably have filed lots of H-1B petitions, so it's not a big deal. And the employer just needs to know to be able to make plans accordingly. The employer is not required to participate in this. So if you say, well, I have OPT valid for a year and then I'll need H-1B status, will you support that? The employer is not required to. So that's something, as you're looking for a job, you want to be thinking and finding this out, because if an employer does not sponsor H-1B petitions, then you might want to look to another employer. If your goal is to stay and work in the U.S., you want to be thinking about that. The employer fees, that's another surprise that the employer doesn't like to hear at the last minute that, by the way, you need to cough up $1,500. Usually you want to get that out in the open. You also want to think about, are we going to have an attorney involved here? And then if we will have an attorney involved, who's going to be paying the fees? That's an important thing to think about. I mentioned earlier that I would talk more about that $1,500 fee, and then the $500 fee, the $320 processing fee, $325, and then legal fees. There is a Department of Labor regulation that says that the employer must pay all of the H-1B costs, filing fees, legal fees, all those expenses. That's in a Department of Labor regulation that, and we talked earlier about the prevailing wage. And where this becomes important and something to consider is that the $1,500 fee, that's off the table. So the employer has to pay that. There's no exception to that. When we talk about the rest of the fees, so we're talking now about $320, $500, and then legal fees. Let's say that the rest of those fees are $2,000. And the employer requires the individual to pay those $2,000. If the prevailing wage is $50,000, and the employer offers to pay $50,000, but requires the individual to pay $2,000 in legal fees and filing fees, the Department of Labor would take the position that the employer is not complying with the prevailing wage. There'd be a $2,000 reduction. That's in the Department of Labor regulation. So that's one agency involved. Another agency involved is Citizenship and Immigration Services, which is the agency that processes the H-1B petition. I've had this discussion with a lot of individuals and a lot of employers about what that Department of Labor regulation says. The Department of Labor is very firm on the position. That's its view. I think, and if you talk to a lot of immigration lawyers, that the subject is not so settled. Because a lot of immigration lawyers don't think that it's the Department of Labor's position to determine who pays for legal fees or other expenses. I understand the prevailing wage, but when it comes down to allocating those resources, I'm not sure that that's an appropriate decision for the Department of Labor to make. I have yet to find an employer willing to go on the federal court litigation adventure to fight that out. But that's something that, I bring that up in this context, not because I'm suggesting that you walk into your employer's office and say, you got to pay these fees or I'm out of here. Because you're probably going to be out of there. But just so that you're aware that there is that tension between the Department of Labor and then the Citizenship and Immigration Services, which doesn't have any firm position on that there's the potential, if the employer does not pay those fees, that the employer at some point, if there were an investigation, may be on the hook to reimburse those fees to you if you were required to pay them. But again, this is something that I think these things are subject to negotiation. The employer needs to be informed, you need to be informed, and then make the best decision for your situation. I'm not advocating one way or the other, but I just wanted to raise that as something to think about. And then when we talk about the role of legal counsel, if you have immigration counsel involved, at my firm, we view our representation as helping both the individual and also the company. And we're not taking sides. And that's something when the question comes up, well, should we pay $50,000? Should we pay $52,000? What about these $2,000 in expenses? That's between the two of you. Our view is to represent both parties. As long as the employer wants to hire an individual and an individual wants to work for that company, we view it as dual representation. We're representing both for the same benefit. Some different attorneys may have a different answer on that. When it comes to the prevailing wage, I view my role as determining what the prevailing wage is, not to negotiate wages. So I won't be saying you need to pay more, you need to pay less. I'll say the prevailing wage is $50,000. If you want to employ this person, that's what you have to pay. And then we talked earlier about the different sources. So maybe one source says the prevailing wage is $50,000. Maybe we can find another source where the prevailing wage is not $50,000. There might be a survey available that would say that it's maybe $45,000. There is a potential for conflict of interest between an employee and employer, and where that could come into play, I talked about the portability going from one employer to another. If you work for company A, and then you want to go to company B, you may need to, if there was an attorney involved, if you have questions about that transition from A to B, you may need to talk to an attorney who was not involved in the H-1B petition for employer A. Because as I mentioned, if you look at number one, it's a mutual benefit. Now the interests are diverging. So if you want to go work for another company, then you may need to talk to another attorney, if there was an attorney involved. The benefit of having an attorney is that I just had a call today asking some general immigration questions, is that this is what we do every day. And we can look at a particular situation and determine what in those different regulations applies to your situation and what doesn't. There's a lot of information out there, some of it applies to you, some of it doesn't. The benefit of having an attorney involved, especially with an H-1B petition, is to look at your particular situation and determine what the planning options are. I always recommend, if you are going to retain an attorney, or your employer, prospective employer, is going to retain an attorney, that you seek out an attorney who has experience in immigration law. It's a very specialized field, just as a lot of things are specialized. This one is highly specialized. There are a lot of attorneys who focus on immigration law, and if you're going to retain someone, find somebody who has experience with immigration cases. When you make initial contact, if you are going to be the one, if your employer does not have immigration counsel and you're the one who's going to be seeking out that attorney, whether it's for an H-1B